Good evening, this is Viewpoint. I'm Zaka Jacob. The Karnataka High Court, in a significant judgment today, has ruled that hijab is not an essential practice in Islam, and therefore wearing hijab in colleges is being struck down. Now, this draws a line in the sand in what can and cannot be done in institutions under the freedom of religion. The court has also said that applying a uniform in institutions is a reasonable restriction, and all fundamental rights come with reasonable restrictions. Will the protesting Muslim students and activists who've been instigating them, will they finally comply with a verdict that's been put down as the letter and spirit of the law now by no less than a high court of the land?
Months after a group of Muslim students in Udupi were banned from entering their classroom wearing the hijab, the Karnataka High Court upheld the ban. Their reasoning? The court found that hijab is not essential in the practice of Islam. The uniform prescribed by the school is only a reasonable restriction, and students can't object to it. And the Karnataka government order banning wearing clothes which disturb equality is not violative of rights.
In the interest of the future of children's education, everybody should obey the orders of the High Court.
The three-judge bench called the protest that broke out in the aftermath of the hijab ban as engineered. The court questioned how the issue popped up all of a sudden in the middle of the academic year and said it was blown out of proportion by the powers that be. The court said unseen hands were at work to engineer social unrest in Karnataka. Remember, CNN News18 was the first to report that 8 Muslim girls had joined the Campus Front of India in November last year. And soon after that, students turned up to class wearing hijab.
ನಮ್ಮ 6 members ಇದು ಸೇಮ್ ಒಪಿನಿಯನ್ ಇದೆ ಈಗ ನಾವು ಹಿಜಾಬ್ ಇಲ್ಲದೆ ನಾವು ಕ್ಲಾಸ್ ಹೋಗುವುದಿಲ್ಲ.
After the verdict, a political slugfest erupted.
It is a kind of discrimination that you cannot wear a hijab and come to school. No one can force anyone to wear or not to wear or what to eat. That is part of the individual privacy.
I shall be very grateful to him if he can show me any line from the Quran that only is considered as Allah's command. Let him show one line from the Quran.
The order is clear. It's school before scarf. But will it be accepted by all?
All right, already the petitioners and their lawyers are saying that they will move the Supreme Court, but this is a reasonable order by all stretches of the imagination. Let me go across now to Advocate Anubha Srivastav Sahai, President of the India-Wide Parents Association, Saira Shah Halim, author and activist, who will be joining us, Ashutosh Srivastav, Supreme Court lawyer, and Fatima Sherin is National Committee member of the Campus Front of India. Let me start with Sherin, because you've also been at the forefront of opposing this order and opposing the order that was put out by the Karnataka government saying that hijab will be banned. Now that the court of the land, a high court no less, has ruled that this does not constitute an essential religious practice under Islam, will you accept this?
Of course, this is condemnable because court cannot say that this is not an essential practice of Islam. There is religious scholars who is determining what is essential in your religion and what is not essential. And of course, there is also this provision of freedom of conscience. According to that also, we should consider that wearing hijab is a right of an individual, and we cannot impose what to wear upon a person. Of course, there is reasonable restrictions, but the reasonable restrictions happen when there is disruption happens to public order, morality, or health. But in this case, I cannot see any of these problems. That is, I wonder how the court can produce such a judgment.
No, it's a very clear, laid out legal practice, Sherin, and I'm sure you will go back and refer to law books on this. Essential religious practices is a test of legality established by no less than the Supreme Court, and as I understand it was in the Shirur Mutt case way back in the 50s and 60s, where for any religion, not just for Islam, for Hinduism, Christianity, Sikhism, any religion, a practice has to... No, one second, let me finish. Has to stand what is called the ERP, or the essential religious practice, for it to be considered fundamentally inviolable. But anyway, be that as it may, let me now ask Advocate Anubha Srivastav Sahai. The court has also said that every fundamental right, and the court is right, every fundamental right comes with reasonable restrictions. So in an institution such as a school or a college, prescription of a uniform is a reasonable restriction. Advocate Sahai.
Yeah, absolutely right. Thanks for having me here. And I welcome this order of the Honorable High Court of Karnataka. And not only this time, in fact, in 2000, TMFI judgment is a very landmark judgment of 11 bench judgment, where the the matter was different, that was pertaining to the fee regulation. And the Honorable Court has said that yes, there has to be a reasonable restriction. Government cannot completely regulate the schools and all, but there has to be a reasonable restriction in terms of the fees and other administrative purposes. So as far as the school dress code is concerned, be it in school or maybe in college or anywhere else, if there is a prescribed dress code, then each and everyone has to follow, be it for the children, be it for the teachers, or even for the parents.
Yeah.
So as far as the school dress code is concerned, if a school is allowing anyone to wear hijab in their school premises for a particular span of time, like in Kashmir, we can see there are some public schools, there are some private schools, they do allow. So it's up to the schools, institutions, and the committee to take a call whether they will permit such kind of hijab or maybe any other dress code inside the premises of the school or not.
Advocate Ashutosh Srivastav is also joining us. The petitioners say that this is an infringement on freedom of choice. Now, I don't know how it is an infringement on freedom of choice, because, like I said, all fundamental rights come with reasonable restrictions. And if you're that concerned about freedom of choice, you're always free to choose those institutions or schools which allow you to wear a hijab. There are enough number of private and public institutions in this country that allow you to choose to wear the hijab. So nobody is restricting your freedom of choice there.
Absolutely. I think Karnataka High Court has really applied its mind by hearing both the parties at length, and sufficient opportunities have been given to the petitioner also to prove that hijab could be a part of the essential religious practice, but it could not happen. Obviously, the court had considered each and every aspect of the constitutional provisions, and also Karnataka Education Act, and also the Muslim Law of Application Act 1937. And nowhere the petitioner could prove that this is an essential part of religious practice. And of course, a school or colleges are a place where religion should not be carried. I think it is against public order, and the equality should be maintained. Article 14 of the Constitution says that everybody has to be treated equally. And the basic purpose of the uniform is that nobody should be, judged by their, religion, caste, or maybe with their money or money power, or whatever their positions are. So everybody has to be treated equally when they enter into any educational institutions. And that is the basic idea of any uniform.
Saira Shah Halim is also joining us, and I think there was a previous Kerala High Court order which said the collective rights of an institution, that was of course in the matter of a convent school, in the matter of a private school, which said that the collective rights of an institution are of higher degree or higher preeminence compared to the rights of an individual. But today, Saira Shah Halim, I want to ask you, now that the court has gone through this matter, the petitioners had a chance to argue and present their case before the court, and they failed to convince the court that wearing of a hijab is an essential religious practice under Islam. After all, there are millions of Muslim women, even in India, across the world, who do not wear the hijab. You can't call them, non-Muslim, or you can't call them bad Muslims just because they don't wear a hijab. So the same should apply to Muslim students who go to school.
See, I am a Muslim woman and I do not wear the hijab. I say that once again. However, the recent Karnataka High Court order is nothing but discrimination against Muslim women, because here Muslim women are being given the choice between choosing their religion, which they feel they have the decision to decide whether the hijab is intrinsic to Islam or not, and education. So here we are going to leave out a lot of girls who are in the middle of exams and they will miss an entire academic year. So here, whatever we are seeing, the discrimination which is happening, which is supported by the state, and what our fear is, it will soon spill out in the streets.
Saira, I think there's a factual. No, one second. I'm sorry, I'm interrupting, but I think there's a factual inaccuracy in what you're saying. I don't think the court is forcing them to choose between education and the hijab. It is these students who are forcing themselves to choose between education and the hijab. This should have never been a binary choice to start with. And I'm amazed and appalled. May I also add, when I'm saying this, I'm amazed and appalled not just at those students, they are 14, 15, 16-year-olds, but I'm also amazed and appalled that those parents who are choosing the hijab over education of their own children. I mean, what sort of parent do you have to be that you don't put education as the most important thing in your child's life? Everything else should come secondary. There are today parents who are saying, don't take the board exam, don't take the college exam because you're not being allowed to wear the hijab. What sort of parenting is that, Saira?
You definitely have a point there. However, what I'm trying to say is that the annihilation of fundamental rights is what is unfortunate. I think this needs to be reappealed and further addressed to the Honorable Supreme Court of India, because here the ruling by the court that hijab is not an intrinsic part of Islam is not going to be decided by a political party. I think let the people of the faith decide, or let the women, because I think women have agency. So why do men feel that women do not have the agency to decide what is intrinsic to Islam or not?
No, again, I said this to Sharon, I'm saying this to you as well. Essential religious practice is a legal test that was devised by the Supreme Court of India, and it applies this in the case of all religions, not just Islam. So when it is applied in the Shirur Mat case, in which it was the essential practice in a Hindu religion, then you're okay with it. But suddenly, when it's applied in the case of Islam, it's not. I mean, you can't have one set of standards for one religion, another set of standards for another. But let me go back to Sharon. What I'm worried about and what I'm particularly concerned about is, the rate of enrollment of Muslim girls in primary education, and particularly the ones who pass out secondary education, is still very low. It's much lower than the national average. So at a time when more and more parents and more Muslim students should be not only enrolling themselves but also making efforts to pass secondary school exams and thereafter go to colleges and earn degrees and join the working force, to say that is not important, hijab is more important, I mean, that's a false choice you're imposing on yourselves.
Yeah, I think this is just...
How can you
Sharon,
say that is a false choice? You are making the passage even more narrow with putting this kind of restrictions. See, I believe that the purpose of a uniform, I believe that there is two purposes for that. One is to reduce this economic inequality in between the students and to identify them. See, when I wear hijab, that doesn't make any issues like that. I mean, they are not asking to wear whatever they want. The students are ready to wear hijab according to the uniform. Means this is an educational institution run by the state government, or receive the
no, but
aid
Fatima,
of the tomorrow
Hindu students say I'll wear the uniform, but I'll also wear a bhagwa scarf on me. Would that be acceptable? Or Christian students say, I'll wear the uniform, but I'll wear a giant crucifix outside my shirt. I mean, is that acceptable?
See, you have been earlier telling
who is going to stop this?
See, this is the court verdict saying that this is not an essential practice. This is ridiculous. There is millions of people
when court has ruled when court has ruled Sharon, when court has ruled certain practices are not essential in Hinduism, you're okay with that. When the court has ruled certain religious practices are not essential in Sikhism or in Christianity, you're okay with that. But somehow when it comes to Islam, you won't accept that. It's a legal test. It's not a religious test. It's a legal test. And are you telling me courts of law in this country are not competent to devise a legal test?
If it is a legal test, I would have to admit that the court has miserably failed in this test. Because please, you earlier told me you were earlier telling that there is millions of people who doesn't cover their head, and still they are Muslims. Yes, also there is millions of Muslims, they strictly believe that covering their head is a part of their religion, and you are all of a sudden asking them to stop that.
No.
Stop
One
to
second.
do that.
Again, I
Of
want to bring
course-
Advocate
of
Sahai.
course there would
I
be
want to bring in
fallout
Advocate
the
Sahai into this
education.
conversation. No, one second. What the court is essentially saying today is, in a school or a college, an institution, the court did not say, Advocate Sahai, that you can't wear the hijab when you're at home. Or the court did not say that you can't wear the hijab going out to the market or to a mall. Of course, people are free to wear what they want to wear. But when you come to an institution like a school or a college, then, and particularly in those institutions where there is an explicit dress code, then it's the primacy of the institution that takes preeminence. It's not the rights of the individual. Advocate Sahai.
Aware that the schools
No, one second,
are very
Advocate Sahai.
rigid.
Can you repeat it again?
No, I'm saying again, students like Sharon are saying, how can you stop us from wearing what we want to wear? I don't think the court decision today stops them from wearing what they want to wear at home or in a market or in a mall. They are free to wear what they want to wear. But in a school, in an institution which has a dress code, you have to follow that dress code.
Absolutely right. And my appeal to all the students also, that see, don't get misled by so many debates and all, whatever is happening. Law of the land is applicable for everyone, each and every citizen. When there is a rule that the school code will be applicable, school dress code will be applicable, whatever school will decide, or any educational institution or any company or whosoever will decide a dress code, you have to follow, be it an educational institution, or if you are applying for a job, then also you have to follow their dress code, that 5 days a week. Even we as a lawyer, we have to follow our dress code. So as a citizen of this country, we are a progressive country. We are a progressive country and we have to move ahead. We cannot just keep on debating on these petty issues where the dress code comes first and then education. We have to give importance to the education. Girls' education is very important in our country.
Absolutely.
Girls are out of school, they're not able to study properly, and because of all these hurdles by their parents, by their community.
And again, I say, I pity those parents who say that education of their children is less important than them being able to wear the hijab. I'm getting a piece of breaking news. You can see this flashing across the screen as well, and I'll get Sarah Shah Halim to weigh in. This is, of course, expected legal procedure. The petitioners are now saying that they will challenge this in the Supreme Court, and a plea has been moved in the Supreme Court against the hijab ban that was upheld today by the Karnataka High Court. The plea has been filed in the Supreme Court challenging the High Court order. We don't know if it's been listed by the court or by the registrar's office. That we will get details on soon enough in the next few hours or so. But this is the latest piece of information, that this legal battle has now moved from the Karnataka High Court to the Supreme Court on expected lines. A plea has been filed in the Supreme Court challenging the Karnataka High Court order upholding the hijab ban. Saira Shah Halim, I want to come and ask you, many of us went to convent schools, right? Went to missionary schools or Christian schools. There, we were all okay with following the dress code. There, none of us insisted that we have to wear a hijab or a burqa or any other dress that is outside of the purview of the dress code. So if it is applicable in convent schools, why can't the same be applicable in public schools? After all, this is a secular state. It's a secular country. The state should not be seen as openly espousing any one religion or the other.
Okay, so Zaka, I have studied in schools that had a very strong missionary feel, and I studied in convents and schools with very strong Christian ethos. Again, I'm repeating, nobody in my family wears the hijab. However, I'm talking about personal choices and agencies, because there has been concerted efforts, by the state and the system to otherize Muslims. And here, why can't you allow Muslim women to decide whether the hijab is an intrinsic part of Islam or not? Why should the courts decide that? And here,
because again, like I said, it's a legal test. It's not a religious test. Please, I would refer Saira also to go back and read the Shirur Mutt case in 1954 or 55, if I'm not mistaken, where in that case, it's a pretty historic judgment of the Supreme Court. There were certain Hindu practices that was challenged in the court, and the court devised what was called the essential religious practices test. And there, even that practice failed the test of law, failed the test of ERP. So if it's okay in Hinduism, why are you against when the court decides in the case of Islam? Right? You can't have two sets of standards. Saira.
No, because here this whole thing, intrinsic to Islam or not, it needs to be challenged because it is confusing. It's confusing to people because here the girls have been wearing the hijab all along, and they were not some kind of a public nuisance to the school or the college.
That again, I'm not sure is entirely accurate because my understanding is in these same colleges in Udupi from 2004 onwards, there was a dress code and students were were following the dress code. It was only until as recently as December that some of these girls, I think 6 of them to start with, insisted that they will only sit with a hijab inside the classroom, and that's what sparked off this controversy. We'll leave it at that. I'm totally out of time on the debate. Earlier, I also caught up with the former Attorney General of India, Mukul Rohatgi, on the legal implications of today's verdict, because clearly the verdict today draws a line in the sand that when it comes to the collective rights of an institution like a college or a school where there is a dress code, that has to have primacy over individual rights. And more importantly, the court has also said that imposing a uniform or prescribing a uniform is very much a reasonable restriction, as is the case with all fundamental rights. So there is nothing wrong in this reasonable restriction on Article 25, the freedom of religion. Historic verdict today by the Karnataka High Court deeming that wearing hijab is not an essential practice in Islam. Your first reaction to this verdict by the court today?
I am very happy with this verdict. This verdict will ensure that classrooms are meant to study. They are temples of learning, and classrooms are not temples, mosques, churches or gurdwaras or anything else. I have another thought which I wanted to share with you, Jacob.
Sure.
See, it is the job of the court to decide whether it's a religious essential practice or not, as was done in the Triple Talaq case, which I had argued when I was the Attorney General more than 5 years ago.
True.
But more important, according to me, the more important, whether it is an essential thing or not an essential thing, the fact is, you must leave these things at home or these issues at home when you enter a classroom. There is no difference between the rich and the poor. There is no difference between somebody who's excellent and somebody who's average. It is a class in a school which is the first thing is it teaches you uniformity.
The other aspect that the court has covered today and explicitly said that uniform or the prescription of a uniform is very much a reasonable restriction on Article 25, and all our fundamental rights are bound by reasonable restrictions. I want your thoughts on that.
Yes,
yeah.
I have no doubt that the court is absolutely correct. As I said, you must leave these issues at your house. You cannot carry them to a school. You cannot carry all of this or some part of it even to a workplace. Let's say a court. A court also has a uniform. You see lawyers wearing a uniform.
Yes.
We have a jacket, we have a band, we have a white shirt. Somebody can say in court, I have a religious practice of either wearing a hijab or not wearing anything. Is it, I mean, does it stand to reason? This country is secular.
Yes.
Secular does not mean that you will wear it on your sleeve. You have religion, you have your practice, nobody is stopping you, nobody is saying don't follow your religion or preach or do what you like. Absolutely. Therefore, the High Court is absolutely right.